I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP, and welcome to our 31st compilation video. Before I give you the rundown on the judges, I want to say, first and foremost, thank you as always for all of the activity that you guys have been doing when it comes to the channel. It's been amazing. You guys have really been showing a lot of love, and I want to say thank you for that. Second, know that there will be no commentary from me at the end of these proceedings, and also chapters will be added just in case you want to jump around. But today we have 3 judges, but we also have 3 sovereign citizens that we covered multiple appearances from on this channel. I will put the links to those other appearances in the description of the video. But the first judge's courtroom we're going to be in is Judge Erane Washington out of the state of Michigan. Second, we will be in the courtroom of Judge Jennifer Grant out of the state of Washington. And third, we will be in the courtroom of Judge Mark Slavens, also out of the state of Michigan. With that being said, guys, as always, it's a blessing to bring these videos and these proceedings to you guys. And without further ado, guys, let's go ahead and jump into these proceedings.
We're moving on to the 3:30 docket at 4 o'clock. And I did play a little catch up. 1 point, we were an hour behind. What we call the case of Country Meadows Apartments versus Samar Tarika Day and Erica Witherspoon. Case number 23C0276.
Good afternoon again, Your Honor. Christopher Borkin for the plaintiff.
Where's my motion? Oh, I see it. There we are. All right. So first of all, there was Mr. Day. Could you please state your name, sir?
I'm Samar Tarika Day.
Thank you, sir. All right. So first of all, the court had adjourned this because I had some concerns about Mr. Tarika Day's capacity to be able to represent himself in this particular case. I do not find authority for the court to refer in a civil matter. So therefore, we'll have to address this matter like any other normal matter. Mr. Borkin, did you receive Mr. Day's motion?
I did, Your Honor. He emailed it to me following the hearing.
All right. Mr. Day, at this time, you can go ahead and argue your motion.
The motion is that making an interim claim against the property, the alleged property, 251-302 Stevens Drive. Like I said, I sent my affidavits to you that have not been addressed, as well as the affidavit to the plaintiff that has not been addressed. And I'm just here to see if the plaintiff is going to rebut any of the claims that were made within the correspondence.
Thank you. Mr. Borkin.
Your Honor, I would respond to this motion by saying that it has no basis in Michigan law, landlord-tenant law. It's not within the court's jurisdiction to grant the relief that he's asking or
Objection.
Claims that he's bringing. Mr. Day, I didn't interrupt you. I'd ask that you grant me the same courtesy. Your Honor, I'd ask you to
Mr.
deny the motion and set this either for trial or be prepared to take testimonies if I find no triable issue.
Okay. Mr. Day, is there anything you would like to say?
Yeah, I was attempting to keep this private because I don't want to cause any confusion out there. But I did send you a document in your ex officio capacity, placing you as a fiduciary to this case and account, and which was not answered. So a notice of fault was sent stating that you agreed to the claims within the initial executive order, affidavit high prerogative writ of quo warranto to take over the assets of the case to charge it off to the plaintiff. But as I've sent the response to the plaintiff, if the plaintiff is not prepared to address the response, as it was stated to the plaintiff that they had until today to address all of which was requested to be addressed in the response or in the correspondence to the plaintiff. If they weren't prepared to answer all those today, then the case would be dismissed and the account would be satisfied.
All right, so my ruling on the motion is exactly what Mr. Borkin said. First of all, I don't have any jurisdiction over whatever issues you're bringing up because those are not actual issues. Secondly, that's not an actual motion. There is no basis for the motions that you filed in the law as we exist.
Objection.
Sir, if you object again while I'm talking, you're going to get held in contempt. Do you understand?
I don't understand what you're saying. I'm trying to I understand that the court doesn't have jurisdiction because it's
over your
the property.
motion. There's nothing that you have said that is even a real motion, sir. The motion is denied.
It's an affidavit. It's not a motion.
All right, I'm going to schedule this for a hearing, at which time, sir, I advise you once again to go seek legal counsel. It appears you didn't do that at all. And then I'm going to schedule it on the 24th. Are you available, Mr. Borkin, on the 24th?
I would be, Your Honor.
I would not be available.
Then if you don't show up to court on that day, sir, the hearing will be held without you.
According to the Judicial Code of Conduct, you're supposed to extend. I'm not a United States citizen. I'm a foreign national, and I'm here under my nation's constitution, laws, and bylaws. And I'm only here to settle the matters at hand. This is dealing with trust property. The property in question has been conveyed to the Tariq Samar Tariq Kade Living Trust, along with the personal information of the alleged defendants, which is now being used in the public without just compensation for the use of that private property. A promissory note was signed, the lease was signed, but full disclosure was not given that what was taking place was a consumer credit transaction, and cash is not a necessity to satisfy a consumer credit transaction. But with it even being a consumer credit transaction, full disclosure wasn't stated that the lease and the private property of the signature of the alleged defendants will be used to securitize that lease, and which by itself destroys or separates the lease, which is the bill, and the security, which is the signature. Because without us, the reason why you don't have subject matter is because we give the subject, which is the property, we make it matter, as we were the ones to sign a consumer credit transaction. But we weren't offered the remedy of not having full disclosure. Within any contract, full disclosure is a must, and we weren't granted that, along with the other issues that brought this whole account up, within the public. So if we need to address it at a later date, I would say no, because I have already brought forth my claim, and my claim has not yet been rebutted. To say that what I have to say as a national or foreign national is not recognized by you is dismissive, and that's religious discrimination, because all I'm doing is what Article 1 of the United States Constitution says. It gives me a right to perform my religious execution. I have the right to religious freedoms, in which you're stating is you're trying to, or your statements have been dismissive towards my religious freedoms, which would be discrimination on your part. And I know that's not what you're attempting to do, but that's what is being done. And along with the discrepancies with the plaintiff. And all I'm here to do, ma'am, I understand what you asked. I didn't understand what you asked our previous date of stating that you felt I was incompetent or that I didn't understand the procedures that were taking place. I just wanted to be private, as I didn't want to cause confusion amongst the masses out here, because I'm not a United States citizen like most of the people on this call. I'm a foreign national, and I come under the laws of my country and under my nation and under my constitution, along with international law, such as the United Nations Declaration on the Rights of Indigenous Peoples, along with the American Declaration on the Rights of Indigenous Peoples, which give us the right to self-government, self-determination, and self-autonomy.
Mr. Day, you've talked.
Yes, ma'am.
I will see you on March 24th, 2023 at 3:30.
Is this excuse me, what is the type of case this will be?
No, I have it. Let's address it. We can address Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council table if you would like to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to. I don't have to come up there for you to hear me. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said, because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster,
I reserve all rights.
I did put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby counsel.
Well, without my permission. He has no permission to be my counsel. I am here sui juris, appropriate persona. I, Jonathan Troy Faifuleo Somalia Colin Schuster, am here under fraud, menace, and duress. I have made a special appearance to this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you.
Well, right now,
to answer them?
I am not here to be interrogated by you. You are under the jurisdiction of this. I think you understand and you choose not to take in the information. Okay, well, Mr. Schuster.
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris appropriate persona. I'm here of my own right in my proper person. He does not have my permission to represent me in any way.
Well, it doesn't sound like you know how to represent yourself either, which you would
represent myself.
Well, you would. Either you have counsel or you are acting pro se.
Myself. And so, like I have told you, I'm here sui juris appropriate persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction, or is this an admiralty maritime jurisdiction?
Either. So, right. Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I
If
reserve
you
all
would
my
like-
rights. If you
If
cannot,
you would like,
I will
if you,
step up so you can hear me better, and I will
none of
speak
it's being,
louder.
none of it's being
I will
preserved.
speak
until you-
louder so you can hear me, but I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just
Schuster,
want to make sure that
Mr.
the reporter
Schuster,
can hear me.
you are making legal arguments. All right, you are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
So-
begin again so that the recorder
You're
can
not
hear me.
choosing to be silent, you're choosing to make a legal argument, so we need to have that on the record.
For the record, I reserve all rights.
You've made that.
I, Jonathan, Troy, Faiz, Olea, Somalia, Toa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of having entered in any international contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and explain how I'm party to it and then compelled to perform under it.
Your Honor, I may be challenging 1077 in this case.
I understand that the city's bringing up whether or not you're able to proceed in this matter. So whether or not you're able to understand the nature of the proceedings and be able to assist your attorney or to represent yourself, you have to be able to meet that threshold. And the fact that I think it's not that you don't understand, I think it's you choose not to understand and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's due to a mental defect that is causing you to not be able to
challenge my competency because I have challenged the jurisdiction of this court, and you have not proved jurisdiction.
In Social Security or contracts
You
or
have to prove
maritime.
jurisdiction before we can move any further.
So that's just not how it works in this court, and
No,
I don't think
that's
you
how
have
it
the
works.
legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, Jennifer, Miss Jennifer, can you prove
I'm Judge Grant, so I'm going to have you.
Can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding.
I do not understand the nature or cause.
Well, he doesn't have legal training, so that I think is
that does not matter.
Well,
if I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my Social Security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody, and we cannot move further until you've proven jurisdiction.
So, Ms. McDonald, what I think would be the next steps, I don't know if Mr. Perrin, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance.
Okay.
So I'd ask to withdraw his.
So we could go through the colloquy, we can provide him with the form for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So Ms. McDonald.
I don't have a problem setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the waiver of right to counsel.
Oh, absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I
You
understand
have
that.
speedy trial at
It is the
August
burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter with prejudice. And I motion to dismiss this matter with
Denied,
prejudice
denied.
based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone for you if you'd like.
We cannot move until jurisdiction has been proven.
Yeah, it should be a,
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
So Mr. Schuster, did the court say that was August, end of August, or?
it was August 9th is speedy trial.
So
And if you plan on having me back here, you're taking away from my ability to provide and work. And I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom court available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
All right, so Mr. Schuster, you've been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court. And, you know, the consequences are extreme for you. You are subject to another court and they could very well.
Get in trouble and you have to prove jurisdiction. You haven't done that. And you've failed to do
Obviously,
that
you
over
believe
and
that
over and
courts
over
do
again.
have
And so, I
jurisdiction
mean,
over you.
Obviously, you have to be able to prove it and you haven't. And you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is. And this is just a waste of time at this point. So whatever you need to do to prove jurisdiction, but I know you can. So if you want to waste more of everybody's time, go ahead. Because obviously I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity. And that's ridiculous for what's going on here. That's absolutely ridiculous. And so
I don't think
this matter
anyone
needs
is
to be
told that you're
dismissed
being
with
put into
prejudice.
captivity.
And whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead. But obviously you can't prove jurisdiction. So
I'm looking for the more
waste everybody's
detailed
time, please.
counsel
Waste everybody's
waiver.
time. It's absolutely ridiculous.
I don't know that he's done that yet,
No, he hasn't. I have the streamlined version, but I want him the formal,
the detailed one.
the detailed one.
We can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
All right.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel. And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has potential jail consequences and fines.
Ms.
And so
Jennifer,
your rights need to be
have-
protected.
This
This is for your benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. And I won't stand for you violating my rights. And if you're going to acquiesce, then okay, you're proving that you don't have any jurisdiction.
So this is a detailed advisement should you wish to waive your right to have counsel present and you want to act as your own attorney.
I said over and over again that I'm here sui juris and propria persona. You know what that means.
This case is going to be going to trial, so you need to have counsel.
I'm here of my own right in my proper person. You know what that means.
So there's the form.
I've never signed my power of attorney away to anybody, especially this.
You need to be respectful. You are really out of line, Mr. Schuster.
I didn't say anything disrespectful.
You are being very disrespectful.
You were being very disrespectful, actually,
because
you're violating my rights.
So I'm going to set this on for the August term. I'm going to have you take this form.
Wasting my time.
Mr. Schuster.
When you're taking away my ability to provide and work.
Have a seat there so you can fill out this form.
What's that?
You can have a seat there so you can fill out the form.
You're dismissed. Do you need anything else?
Yes, I do. I need you to take that form. So we're going to have to go through that because this case is going to be going to trial. It's going to be set on the August term. That would be August 6th, and that will be at 9 a.m.
All right, you're dismissed.
No, you're not free to leave yet, Mr. Schuster.
I'm not free to leave?
Not yet. No, you're not.
Why am I not free to leave?
Because we are still addressing your matter.
This matter needs to be dismissed.
Yeah, it's not going to be dismissed right now. So right now it's getting set for trial.
You can't move any further until you prove jurisdiction.
And the readiness hearing will be July 31st. And that will be at 2 p.m. And that hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench.
So, Mr. Schuster, if you choose not to come to your court hearings, a warrant will issue for your
You're
arrest.
threatening me again, telling me
Yes,
if I don't
you will be
play your
expected
game,
to appear.
and you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep. These are jailable offenses, but for this
Absolutely
hearing,
ridiculous,
we need your presence to appear.
Absolutely ridiculous.
All right, let's get a court date form for him.
Absolutely ridiculous.
What's the date for the intervening?
Back there?
We can set a pre-trial. Let's do it on the 22nd.
Prosecuting attorney also needs to provide any contracts that I've entered into internationally.
Here's your court date. Could you please sign?
Especially if this is an admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So,
Mr. Schuster, you are in a criminal court, and there are court rules. If you wish
this is a criminal matter,
Mr. Schuster, if you wish to have discovery, then you need to abide by the rules.
Criminal matter?
Yes, and if you wish to have.
Oh, okay. I wasn't sure you said that. Thank you.
Yeah, it's a criminal matter. If you wish to receive discovery, then you will need to make.
What is the jurisdiction? Are we under an admiralty maritime jurisdiction?
No, we are not.
Are we under a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery, then you need to request.
I gave you my permission to be under that jurisdiction, which I haven't.
You will need to request discovery from the prosecutor's office.
I'm a U.S. citizen, American national. That's not a jurisdiction.
If you wish to have discovery, you need to request it in writing from the prosecutor's office, and we will send.
Your nationality was a U.S.
And then we will send you the discovery, all of the evidence that we have against you at trial. Did you understand that?
I don't understand what's going on with this.
So here's my suggestion, Mr. Schuster.
Kangaroo court. And so since you guys are going to waste everybody's time even more, goodbye.
Mr. Schuster, you need to sign for your court dates. I'm giving them to you orally.
You have a good day. Talofa.
If you don't appear for your court hearings that were given today, a warrant will issue.
All right, you can call Ms. Tubbs' case.
Okay. Calling case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P 36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah. Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Sean.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Sean.
Okay, then it says, at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Sean.
Yes, Your Honor.
Right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What day?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under code UCC 1-207. And I have the rights to represent myself and waive all counsels knowingly, willingly, and intelligently. And I would like to.
All right, so you're requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, you know, once I get that, then if she wants to represent herself, then we can, you know.
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
that's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, I'm gonna walk. Would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Sean.
So, ma'am, I'm gonna have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not gonna do it, but I just want you to talk with him and understand some of the risks of doing this. And, okay?
Your Honor, I understand all the risk and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now? Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're gonna need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions, just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I am here to, I'm here to reserve
let's
my
have you
right.
raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you. All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not having you present yourself.
What oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right, well, let's have her raise her hand again and you say the affirmation. It's not an oath, it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No, yeah, okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
Well, I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
punishable up to 5 years or a fine not.
Ma'am, just wait. Let me speak, okay?
I'm sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
All right, ma'am, the maximum possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all, can you give me your educational background?
I
How
have
far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes,
And why do you wish to how many times have you represented yourself?
twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No, that's not what the
Oh.
the elements of the offense are.
The elements. What do you mean
Yeah.
by elements? Because y'all
Well,
use double language.
that's the problem. You
Y'all
don't
use
know.
double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to offend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is
Yeah.
that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge, okay? Ma'am,
Okay, so what?
ma'am,
so
no,
what-
you don't get to quiz me. Ma'am, what do you know what the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Acceptance of the hearsay. Hold on, I want to write all this down.
I'm sorry. No, I'm asking you. You say you know this stuff. How are you going to represent yourself?
You got
don't even know what.
acceptance of hearsay, sir. I would like to write everything you're saying down so I can
Have
be
you
able
ever
to.
have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No. Do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes.
Do you know that self-representation is almost always unwise?
Yes.
Did you know that the first day of law school, they tell us that he who represents himself has a fool for a client? Do you know they tell us that?
Yes.
And so what does that tell you if they say he who represents himself has a fool for a client? What's that tell you, ma'am?
You know what it tells me?
Yeah, what's that tell you?
You all operate in trade secret acts. So
Okay.
you
Well,
will be
that's
a-
not true, but okay. Miss Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah, because you'd have a fool for a patient, wouldn't you?
Correct.
So why do you think you can do law if you can't do medicine?
Because I go by federal law.
Okay. You understand you'll receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Yes.
You understand you'll receive no special help from the court staff and you'll be expected to follow the same requirements that apply to practicing lawyers. You understand that?
Yes.
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made?
Correct.
And accurately and understandably?
Yes.
Okay. Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant your request to represent yourself, ma'am, okay?
Thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report.
Can you
And the
get her
oath of
whatever
office,
discovery
please,
you
so I
have?
can know what I'm dealing with.
All right.
Do you guys
You'll
just go
set-
by maritime law or common law?
Ma'am, it's not maritime law. You need to learn the law, okay? I'm
Well, I know
not advising you on the law. I told you, I'm not advising you. If you don't know what it is, that's up to you to find out. I'm not advising you on anything on the law, ma'am.
Don't worry about it. I know what it is.
Yep, don't ask for any special consideration. You have to perform just as any licensed attorney would here. So if you don't know that, I would strongly recommend you have an attorney represent you if you don't even know if it's a maritime law or not.
It's my right to ask questions.
All right, well, go ahead. As I said, he who represents himself, he or she is a fool for a client, ma'am. Okay, we will have the attorney send you those documents. Madam Clerk, if you can get a standby counsel for this for March 17th at 9 o'clock. Is there anything else we need to take up?
So am I here released?
Yes, you're released.
Thank you, Your Honor.
Your Honor,
But you need to send all the materials to her. And
Your Honor.
also, if we can get her brought here from the jail, Madam Clerk. Okay,
that's what I was going to ask for, is to have her written here and then another date before the trial date where standby and Ms. Tubbs would be here, where we would all be on the same page.
well, we're gonna get the standby and do that right away as soon as we get that.
Okay.
I
We can
request that,
schedule this for, ma'am, don't interrupt me. I don't interrupt you, you don't interrupt. All
excuse
right,
me.
we'll schedule this for February 19th at 9 o'clock for assignment of a standby counsel, okay? And if you can make sure that she is on Zoom that day, Madam Clerk? Okay, is there anything else we need to take up with regard to Ms. Tubbs' case? And you, ma'am, just so it's clear, you're under oath, you are requesting that there not be an insanity defense, is that correct?
That's correct. And I also,
Okay.
February 19th,
Madam
I
Clerk,
have
if you can
something
prepare,
scheduled at 9.
ma'am, don't interrupt me. Prepare an order that says that she's withdrawing any insanity defense. Okay, all right, what, Ms. Tubbs?
I have another court time at 9 a.m. on February 19th.
All right, then we'll make this February 20th at 9 o'clock, all right?
Thank you.
I'm not threatening you. Say one more word and that's 30 days. 30 days.